The guided choice method of design and construction project dispute resolution is a collection of the best practices of, in my view, the best design and construction mediators. While guided choice was not invented per se by my former Schiff Hardin LLP law partner, Paul Lurie, he's certainly the driving force behind a movement which seeks widespread adoption of the principles of guided choice. Now, guided choice involves a half dozen or so core principles, depending on who you ask. And I'm going to touch briefly upon 7 core principles in this video and then address each one in more depth in subsequent videos. I think what's important for people to understand is the role of the advocate in trying to achieve early, cost-efficient dispute resolution, and the role of process and the importance of having a good process in a mediation that tends to lead to that early, cost-efficient dispute resolution that our design and construction clients want to achieve so much. I think there's a real lack of focus on the process issues which drive successful mediations. Many users of conventional dispute resolution services, like your typical mediation, don't recognize that a proper settlement process, which is likely to achieve that early, cost-efficient dispute resolution, consists of a lot more than just exchanging mediation briefs that discuss legal issues and participating in pre-mediation phone calls with the mediator and the parties who are representing the other side, and appearing on a particular date to begin negotiations. There's a lot more to it. And that's why I want to review what I believe are the 7 core principles of guided choice dispute resolution. The first of which is early involvement of the neutral or the mediator. And by that, I mean somebody who understands the guided choice process, who's committed to its principles, who gets engaged essentially as a mediator. We'll sometimes refer to them as a neutral early. And early is what is so important. I'm going to be discussing in later videos why it's so important for this person to be engaged early in the life of the dispute. The second core principle is a commitment of the parties in the neutral to first address process issues, right? So before we're going to talk about the substance of the dispute and when people might get together and talk about actually exchanging settlement offers, there's got to be a commitment of the parties to essentially mediate process issues, to figure out the process that the parties will engage in first. The third core principle is the need for there to be confidential discussions using the cloak of mediation privilege between the disputing parties and their lawyers on the one hand, and the neutral on the other hand, which will allow the mediator to investigate, what are the reasons the parties have reached impasse for settlement on their own, and to diagnose what are the likely roadblocks, the likely obstacles that need to be overcome in the future so that we don't wind up at impasse down the road. The fourth core principle is process design by the mediator and generation of options. In other words, once the mediator has engaged in his or her confidential discussions with the disputing parties and has a better understanding of the reason why they are at the impasse that they're at today, what kind of a process will the neutral design in order to meet the business needs of the parties and to generate the options that are necessary to put parties in a position to make a decision about whether it is strategic for them to settle the case or not as part of the mediation that will play out. The fifth core principle of guided choice dispute resolution that I'll be addressing more in other videos is an information exchange between the parties in accordance with an agreed process. Typically, when people say they're not ready to talk about settling a design or construction dispute, what they often mean to say is that they don't have sufficient information in order to make a business judgment about whether it is in their interest to pursue settlement at this time or not. And even if they're inclined to try to settle, what would be a strategic way of going about engaging in those discussions? And this exchange of information is such an important part of the process. The sixth core principle is anticipating and overcoming impasse before negotiations start, right? So what we're talking about here is the need for the neutral to engage with the parties to try to figure out what is it that is going to be an impasse in a week, in a month, what is it that we can do to see that we're going to hit that roadblock, and how are we going to overcome it? And to do that in a way before the parties are put in the position of prematurely having to exchange settlement offers that perhaps they're not ready to make, right? One of the real reasons why I believe most mediations fail is because the mediators force the parties together prematurely to begin a positional negotiation where one side stakes out an extreme position and the other side stakes out an equally extreme position. And it's prematurely convening those negotiations before the rest of the process is run that leads to that dynamic. And the last core principle of guided choice dispute resolution, which I'll address in more detail in other videos, is the need for there to be an ongoing role for the neutral, right? For the mediator to stay engaged with the parties, even if their negotiations are suspended, even if they make a decision that their strategic interests lie in abandoning the settlement process and not continuing on with the formal mediation process and proceeding on to binding dispute resolution methods like litigation or arbitration. If these interest you, please check out the rest of my videos on the core principles of guided choice dispute resolution.